welcome back. I'm going to try and finish up on chapter 3. I know you got a test coming up. Yeah, it's a tent. That's what we do when we're trying to hide and not get sick from everybody. But anyway, here's what it is. Chapter 3, and really what we're going to talk about today, I'm hoping will tie in a lot of things, especially with what's going on today about defund the police, and really what police should be doing and why they're doing it. A lot of things will get tied in today. Remember, I'll certainly understand or accept the notion that we have police corruption. Absolutely. We have a lot of police that do the wrong thing. We have a lot of police that are doing what they've been trained to do, and it might be the wrong thing, so we need to retrain them. So there's a lot of things here we need to talk about. So when we talk about police corruption, certainly we have internal affairs. IAB, Internal Affairs Bureau, is that part of a department that looks into corruption of law enforcement. We talked about use of force, anything with corruption. What you're hearing a lot today is this idea of a civilian review board or a citizens review board. I love the idea. We had it in Las Vegas, but it's basically civilians that are not involved with law enforcement having oversight and looking when a claim of corruption against the police or use of force, this civilian review board looks at it. And it's something that I think is extremely important, and I think all departments over the next couple of years should have a civilian review board. But let's back up first, because you have to understand, how did we get to this point where cops or law enforcement or what we consider are abusing this power? How did they get the power to begin with? Remember, talking back to the very day one class, there was a lot of crime going on. So the citizens of the United States gave the cops a lot more power to fight that crime. And when I say that, a lot of it has to do with the Supreme Court. When I use the term landmark case means something happened out there. It went in front of the Supreme Court to decide, should the cops be allowed to do this or not? And it changed the way law enforcement did their job. Yes, you're going to have to be responsible for a couple of these cases. First and foremost is Tennessee versus Gardner. In Tennessee versus Gardner, in this case, it was in the 60s. Don't worry about what year it was. But prior to this case coming in front of the Supreme Court, law enforcement, if they had someone that committed a felony and trying to get away from the police, they could use deadly force to stop that person if it was a felony. What happened in this particular case, law enforcement in Tennessee were responding to a burglary in progress. When they arrive at the house, they see somebody coming out of a window of the house. And as they yell for the person to stop, the person doesn't stop. And as they tried to jump up over a fence and get away, law enforcement or the police officers shoot them in the back, killing them. At this point, it went in front of the Supreme Court. The Supreme Court said, no, you're not going to do that anymore. That's gone too far. So Tennessee versus Gardner set the stage back in the 60s that said, you can't shoot somebody for just committing a felony. A lot of things had to take place after that. Can't shoot somebody for just doing a felony. There had to be things where someone's life was in danger. Landmark case. We're going to get to the most important landmark case here in a second. But before I do that, remember, I expect you to understand the Bill of Rights. Read it in the chapter. Go over all of the Bill of Rights. It's clearly important. A lot of you love your Second Amendment right, and that's all you know is Second Amendment. There's a lot more than just the Second Amendment. Specifically, when we talk about law enforcement, where we have a lot of issues today erupting is because of the Fourth Amendment. The Fourth Amendment is this idea that the Founding Fathers came up with, that they didn't want government to intrude upon your home. Things that are important to you, where you live. This search and seizure, unreasonable searches and seizures. This concept is in the Fourth Amendment, and really where we get a lot of issues with law enforcement. Keep in mind, how does the Supreme Court keep this whole game in balance? It's called the exclusionary rule. If the courts can show that law enforcement violated the Fourth Amendment and they did the wrong thing, an illegal act, any evidence that they obtain, they will lose. So they'll lose any evidence that they did if they violated the Fourth Amendment. That was intended to happen. It was a punishment of law enforcement. In the United States, the Supreme Court did it for a purpose. They said if you know you're going to lose your evidence and you're going to be punished, then maybe you won't violate the Fourth Amendment. This concept of fruits of the poisonous tree doctrine is nothing more than an extension of the exclusionary rule. It means that if I do something illegal and I come into your house violating your Fourth Amendment and I obtain evidence, anything attached to that evidence, if I walk down the hall and get more evidence, and then more evidence, everything attached to that illegal point is called a fruit of the poisonous tree. You lose everything. So if the courts can show anything is attached to an illegal event, it's lost in court. An important thing to remember when we talk about the Fourth Amendment. There are a lot of exceptions to the Fourth Amendment. The courts realize that cops have a tough job, and there are times we don't have time to go get a warrant. A warrant is one of those exceptions, meaning you go out, you get a judge to sign a warrant based on probable cause. Remember, probable cause, extremely important. I want you to understand that term. But it's the facts and circumstances. Facts and circumstances. If you write out facts and circumstances of why you think somebody committed a crime and a judge agrees with you, they'll give you an exception to violate their home, a warrant to go through and bust through the door. That's an exception. Another exception is just you have the right to consent. You can give me that right by saying, yes, I know it's my right to not let you have, but if you want me, if I say, hey, can I come in and look in your house and you let me? You have the right. Another exception is, an emergency. We call this an exigent circumstance. Emergencies happen in life. If somebody in your living room is having a heart attack and you dial 911, there's not an expectation that we're going to go get a warrant before we come in your house. Something's going on in your house. It's an emergency. We can come in without a warrant. So keep that in mind. Emergencies happen all the time. If cops are going down the street, we hear screaming, really bad screaming coming within a house, we can go inside. It's an exception. So there's a lot of exceptions to the Fourth Amendment. And read about them as you go through your book, because that's important. But what we're going to get to now is, I've explained to you what probable cause was. Probable cause is what law enforcement needs to have to make an arrest. Facts and circumstance. The Supreme Court had a case back in the 60s, a landmark case. And it's called Terry versus Ohio. Terry, Terry versus Ohio. This is the foundation of why we're having so much problems today. In Terry versus Ohio, the story here was, late at night in Ohio, we were having a lot of robberies happening in business areas. And these robberies were happening with guns. And what happened in this particular case, the cops were walking down the street. They see somebody sitting out in front of a bar, acting very suspicious. The cops stopped them because they were acting suspicious. Upon stopping them, they patted them down or searched them, and they found a weapon. They found a gun. They arrested this individual for having a gun because they weren't supposed to. They were a felon. This person took it all the way to the Supreme Court saying, that was a violation of my Fourth Amendment. You didn't have probable cause. You didn't have facts and circumstances to stop me. And you found a gun and arrested me, and that was a violation of my Fourth Amendment. And that person was right. Prior to Terry versus Ohio, that was right. You couldn't do that unless you had facts and circumstances. The cops didn't have it. However, in Terry versus Ohio, the Supreme Court switched and came up with a new term, and they says, you know what? Cops have a tough job, and we're going to let them do that. Going forward now, we're going to let them stop people that they find suspicious. Very interesting term they came up with. Reasonable suspicion. Reasonable suspicion. Supreme Court says if law enforcement has reasonable suspicion, this is nothing more than a hunch. This is, we call it in law enforcement JDLR. Just doesn't look right. Meaning something's not right here. So because of that, the Supreme Court says I have reasonable suspicion, a hunch based on what I think is a cop. You're acting strange. I can now stop you. This is critical in understanding where we're at today. So cops have the right to stop you based on reasonable suspicion if you're acting suspicious. We were given that right back in the 60s. A lot of things happening today where a lot of jurisdictions want this right taken back and taken away. They think it has taken, the cops have gone way too far, and they have. Clearly, reasonable suspicion had nothing. There was never any right given to law enforcement to stop anybody based on their race or the religion. So racial profiling was never accepted. It was never allowed. You can see that it got to that point because a lot of law enforcement personnel would perceive someone's race, religion as something to be suspicious. Can't do that. Suspicion based on Terry versus Ohio with suspicion of a criminal event, that you were doing something criminal. Remember, racial profiling was never allowed. Terry versus Ohio did a couple of things. Not just allow someone to stop you for reasonable suspicion, but it was the first time that the court said, we'll also allow you to search them, violating their Fourth Amendment. Because remember, your person is like your house. The Fourth Amendment protects you from us searching you. If we have reasonable suspicion, the court said this, and this is extremely important. Yes, you can stop someone if you think that they are going to commit a crime based on reasonable suspicion. But number one, it can only be a brief detention. They never said exactly what that was. Law enforcement has put it as an hour. You can stop them for an hour if they're suspicious. You can pat them down. This pat down term we came up with was for searching for weapons only. So the whole idea that you're patting the outside of their clothing down is you're looking for guns and knives, things that might hurt the cop. So you can stop them if you got suspicion. You can pat them down, but only for weapons. You can't reach into pockets looking for drugs and dope. You can only pat down looking for weapons. And the third thing that has to be there, and the Supreme Court said this in the 60s, you had to identify yourself as a cop. You know, clearly we have a lot of undercover police officers that are not in a uniform. And we've gotten into a lot of trouble for that. Under Terry versus Ohio, you had to identify yourself reasonably to that individual. And then, yes, you could detain him. So keep in mind, as we talk about reasonable suspicion, and about this whole idea about cops stopping people on the street, we get pretty aggressive on the streets, stopping people because we justify that they're acting suspicious. This is one of the biggest things right now we talk about, that maybe we should go back to don't stop somebody unless they have probable cause. But right now, yes, under Terry versus Ohio, it's still there. It has not been taken away. Some jurisdictions like New York City, NYPD, they don't allow their officers to do that anymore. So in some jurisdictions, that chief or sheriff can stop it. Other jurisdictions allow it. So again, it's good to understand that whole concept of reasonable suspicion. And this is really critical in understanding police work. Because today we expect cops to go out there and stop crime, prevent crime. And I've already told you my opinion on that. We're not going to be able to do that. But in trying to stop crime, we stop everybody that seems suspicious. And in doing that, we piss off a lot of people. Terry versus Ohio is one of the main things that got us into the problems that we have today. So remember, this whole idea of reasonable suspicion is there. You cannot arrest somebody for reasonable suspicion. You can briefly detain them, and if you come upon probable cause, then you can arrest them. So have an understanding of all of that, because that's really what goes to the importance of this. We've talked about use of force and about how departments are raised or trained on use of force and those tactics. But if I was to ask the question, how do you make an arrest, or how does law enforcement make an arrest? They have to have probable cause. Remember, not reasonable suspicion. Probable cause, remember, is an entity. Probable cause exists when the facts and circumstances would warrant a prudent person in believing that a crime has been committed and that the accused committed it. That's probable cause. And really that encompasses this idea of the totality of circumstances. That when you look at everything that you've got there, that when I look at it in totality of circumstances, I'm pretty sure that person committed a crime, this specific crime. Let's talk about Miranda before we leave. Miranda, again, this is a landmark case. In Miranda, it was based on your right to not have to speak to law enforcement or incriminate yourself, this Fifth Amendment right. In Miranda, you see it on TV all the time. It's when we read you your rights, basically saying, yes, you're under arrest, and you don't have to speak to us. But I want you to understand, you can talk to us, and there are ways that the Supreme Court said this must, or when we have to read somebody their Miranda rights and then warn them of the Miranda rights, it's because two triggers have to exist. The Supreme Court says, number one, if you have them in custody or they feel like they're in custody and they are asked questions, then you must Mirandize them. So what that means is, if I come to school at SUU and I walk up to you as a cop and go, hey, can I talk to you for a second? And you say, yeah, I don't have to Mirandize you. Clearly I'm asking you questions, but you're not in custody. If I go to your work and say, hey, can I talk to you? Again, you're not in custody. If I pull you over in a car and I say, get out of your car and get up in front of my vehicle, are you in custody? Well, the Supreme Court says yes. If you feel that you cannot leave, so if you're detained because of reasonable suspicion, you are in custody. So at that point, if I start to question you, I'm violating Miranda. If someone's in custody and you're going to question them, you must Mirandize them, telling them you have a right to not speak. So understand Miranda. It's extremely important. You know, before we leave this, just understand, I want the arrest power. We talked about when can a cop arrest somebody. Number one, when they have probable cause and it's a felony. Number two, if a judge issues a warrant, we can arrest. What about a misdemeanor crime? Can cops arrest for a misdemeanor? Great question. And here's the answer. Cops can only arrest for a misdemeanor crime if it happens in their presence. So if you slug somebody at school and you hit them in the face, that's a misdemeanor crime. If the cop didn't see you do it but show up afterwards when you're wiping the blood away, they cannot arrest you. There are exceptions. One of those exceptions are domestic violence. If the two of you have a relationship, yes. But if there's no relationship, you can't arrest somebody for a misdemeanor unless it happened in the presence of law enforcement. So understand that. That's critical in going forward. Another thing, POST, P-O-S-T. That's the state training cops in how to become a cop. You're going to hear a lot about this coming forward when we got all the protests trying to defund police. Are we doing enough to train police? That's a great question. And I say no, we're not. In fact, I think that most cops should have bachelor's degrees. I think we need to train much heavier. But we'll get into that discussion. That discussion's coming, whether we like it or not. So understand how we train police. Having said that, I think we've hit on this enough for a 10-10 class. If you have questions, by all means, send me an email, and good luck on the test.